Turning now to look at the specific data transfers, I thought I would begin with the most straightforward, and that is data transfers from the UK into the EU. So as you will see from the screen, the UK government has confirmed that it is going to continue to recognise existing EU adequacy decisions. And this really means that UK organisations can continue to transfer personal data to the EU without any further action being required. So for example, if you are a UK-based controller, you are able to continue to send personal data about UK data subjects into the EU to be processed without any further action needing to be taken. Unfortunately, the position is not going to be so straightforward the other way around whenever we in the UK are receiving personal data in from the EU. And as I've mentioned, in the absence of an adequacy decision, this is because the UK will be treated as a third country for the purposes of the EU GDPR. And an additional safeguard under Article 46 of the GDPR will be required for data transfers to take place lawfully. As you will see from the slide, the two main safeguards are the binding corporate rules, the BCRs, or the EU standard contractual clauses, the SCCs. So starting with the binding corporate rules, what actually are BCRs? Well, these are just a set of internal rules that apply to all entities within a corporate group. All transfers of personal data within the corporate group can take place lawfully then once the BCRs are in place, and this includes transfers between EU and non-EU entities. The main advantages of implementing BCRs are that once they are implemented, they apply to all transfers within the entire corporate group, meaning that once you actually have them in place, they're very simple to rely upon. However, by the same virtue, the main drawback of relying on the BCRs is the lengthy approval process to actually get them implemented. And this is because if an organisation wants to implement BCRs, it must select a lead data protection authority. So for example, if your main office is in Germany, you may opt to select the ICO in Germany as the lead data protection authority. This authority would then have to submit the binding corporate rules for approval by authorities in the other locations of group companies. So if you have group companies located, for example, in Portugal and Spain, then the authorities in those countries would have to approve the BCRs. And this just means in practice, the approval process can be rather lengthy, depending on where the various entities are located. Another drawback of BCRs is that they only cover data transfers within the corporate group. So if you're transferring personal data to customers, suppliers, or other clients, then you're going to need to have another safeguard in place with these parties. And that safeguard is most likely to be the standard contractual clauses. And I'm going to come on to talk about the standard contractual clauses now. So the standard contractual clauses are just really standard sets of contractual terms and conditions that the sender and the receiver of personal data will both sign up to. And they include contractual obligations which help to protect personal data whenever it leaves the EEA. And the ICO guidance states that in reality, small to medium-sized enterprises are unlikely to have another viable safeguard to rely upon. And this is actually something that I have noticed in practice with the vast majority of my clients turning to the standard contractual clauses, because the reality is for most organisations in Northern Ireland, the binding corporate rules aren't really a very appealing safeguard. And I think that seems to be primarily due to the fact that they do take so long to actually implement. In contrast, the standard contractual clauses are readily available. You can get them from the EU Commission website, and the clauses have to be implemented in their entirety and cannot be amended in any substantive way. So while this reduces their flexibility, it does actually mean that they're very quick and easy to implement. There are two sets of standard contractual clauses. So there are controller to controller and controller to processor. This means that not all data transfers are covered. And this is an issue that I've actually run into in practice. But fortunately, it's hoped that the gaps in their applicability are going to be addressed sooner rather than later, because this is something that has been flagged to the ICO. And again, it's hoped that this will be actioned quite promptly, given that there's going to be a predicted increase in reliance on the standard contractual clauses following the end of the transition period. The main drawback of the standard contractual clauses at present is the fact that they are very outdated and do need refreshed. So the current versions were last updated in 2004 and 2010. Fortunately, the European Commission has announced back in June that it is going to undertake a comprehensive modernisation of the existing standard contractual clauses. You will see on the screen that I have mentioned the Schrems II case again. So this is very important because this case actually saw the validity of the standard contractual clauses being challenged. And this has caused considerable worry for businesses operating globally who were reliant on the standard clauses, and also for Northern Irish organisations who are hoping to rely on the clauses following the end of the transition period. So Schrems II was brought by a well-known privacy activist, Mr. Schrems. Mr. Schrems is actually no stranger to bringing data privacy challenges, and he is the individual that successfully invalidated the previous arrangement with the US known as the Safe Harbour. So this challenge was brought by Mr. Schrems against Facebook, and it was in relation to the fact that he did not believe Facebook's transfer of his personal data to the US was properly protected due to the wide-ranging powers of US enforcement agencies. So the case went through various courts, culminating in the Court of Justice of the European Union. But fortunately, the Court of Justice has held that the standard contractual clauses remain a valid transfer mechanism, albeit with some caveats. So the court held that although the clauses can still be used, data controllers that are sending personal data outside the EEA must assess whether the recipient country offers adequate protection. So in practice, this is going to include reviewing the specific circumstances of the data transfer and also the legal regime of the receiving country. In terms of the UK GDPR should mean that this will not be an issue, although there are some concerns about the wide-ranging surveillance powers under the Investigatory Powers Act 2016. But again, this is something that we're just going to have to keep an eye on and see what happens in the coming months. The court also held that it's prudent to assess whether there are any further protections beyond the standard contractual clauses that may be required. Again, we don't know what these may be, so really it's just a case of waiting and seeing what guidance is put in place by the ICO or the European Data Protection Board. To summarise then, the standard contractual clauses remain valid, and although they are not perfect and do not currently cover all transfer scenarios, the reality is that the standard clauses are the most likely safeguard to apply. And hopefully we're going to have updated versions of the standard clauses before the end of the transition period. Turning next to data transfer from the UK to third countries. The position here again remains pretty much the same after the transition period as it currently is. So as you will be aware, in the very first instance, you need to make sure that you even have a lawful basis for transferring personal data under Article 6 of the GDPR. And if you're transferring sensitive personal data, you must also have an additional basis under Article 9. Following on from this, the next step is to determine if the third country is secure or unsecure. In other words, this just means you need to consider if the EU has granted an adequacy decision on the third country. And you're probably wondering why this is going to be relevant whenever we're no longer going to be part of the EU. But it is, and this is because the UK government has confirmed that it's going to continue to recognise existing adequacy decisions at the end of the transition period. So this is positive news for organisations in the UK because data transfers to countries such as Canada may therefore continue with no further action needing to be taken. The position was also set to be very straightforward for data transfers to the US because the UK government had stated that it was going to continue to recognise the protection offered by the EU to US Privacy Shield. And all that was going to happen was organisations under the Privacy Shield were to update their privacy commitment to reflect that they would be receiving or sending personal data to the UK. So in other words, the Privacy Shield was the mechanism that served as an approved adequacy concept to protect cross-border data transfers from the EU to the United States under the EU GDPR. However, the Schrems II decision that I've just spoken about in relation to the standard contractual clauses did not bring as positive a result for the Privacy Shield and has thrown a spanner in the works. This is because the Court of Justice ruled that the Privacy Shield is actually an invalid transfer mechanism. And their reasoning for this is because US intelligence services can interfere with individual rights. So this ruling has far-reaching consequences and generates greater hassle for UK organisations, particularly following the end of the transition period. This difficulty has been accentuated by the fact that the ICO has clarified that there is no grace period and that transfers under the Privacy Shield are now unlawful and organisations should seek alternative data transfer mechanisms. So as if organisations in the UK didn't have enough to contend with, this is now an additional consideration that must be given when going through their data transfers. This takes me on now to see what we can actually do to ensure that organisations can continue to transfer personal data into the US. So firstly, you should review your data flows. Ascertain the organisations that you are transferring personal data to and assess whether they were originally signed up to the Privacy Shield. It's also prudent to assess the type of personal data. So for example, does it also include sensitive personal data? And also the scale of personal data being transferred. Secondly, you should assess whether any unnecessary personal data is being sent in line with the principle of data minimization. And again, this just brings me back to the wide definition of personal data under the GDPR. So it will cover basically anything that could enable an individual to be identified. So it is possible that organizations could be sending minimal amounts of personal data to the US that maybe they don't really need to be sending. It's also important to consider other tools under the GDPR, such as redaction and anonymization of personal data. Thirdly, you should consider additional safeguards. So as the ICO has stated that there's no grace period, you may wish to consider implementing standard contractual clauses as a backup transfer mechanism. But again, as I've mentioned, you need to remember that the standard contractual clauses are going to be updated in the near future. Finally, you should keep up to date with guidance because it is possible that the UK could obtain its own arrangement with the US following the end of the transition period anyway. So I've now taken you through all of the main data flows and the appropriate safeguards under Article 46. I also thought it would be useful to touch on the derogations that are available under Article 49 of the GDPR. So the derogations that you will see on the slide are for specific data transfer situations, and you will note that these are narrowly defined and are only really applicable in the scenarios that are stated on the screen. So for example, if the data subject has explicitly consented, having been informed of the possible risks of the transfer. In reality, this is likely to pose an administrative burden for large organisations who are transferring personal details of many individuals. Nevertheless, it is there and it could be used perhaps in relation to personal data pertaining to a handful of employees, for example. The other derogations apply when the transfer is necessary for performance of a contract with the data subject, public interest reasons, the exercise, establishment or defence of legal claims, or to protect the vital interests of data subjects. And again, as you'll see on the screen, a truly exceptional transfer for a compelling legitimate interest. The reality is that where data processing is large scale or covers large amounts of sensitive personal data, derogations will be unlikely to apply. That being said, the frequency of reliance on derogations could increase in the future depending on how quickly updates are made to the standard contractual clauses. So far, I have not seen that many organisations seek to rely on derogations, but this could be partly due to the fact that they are not that commonly known about. In my experience, many organisations are familiar with the standard contractual clauses, but the derogations are something that they weren't really aware existed within the GDPR. If you are considering relying on a derogation, I would just like to note that you should keep a clear record of this. And this is really in line with the accountability principle of the GDPR. So make sure you have a clear record of what the derogation is and why you think it applies to that particular data transfer scenario. I have put on the next slide just a summary of the data transfers that we have gone through. I appreciate that I have given you a large amount of information to distill down, so hopefully the information on the screen just really makes that very clear. And just to quickly go through, data transfers from the UK to the EU remain valid and no additional safeguard is needed. EU to the UK, a little bit more complicated. If we don't have an adequacy decision, these will be restricted and you will either need an additional safeguard under Article 46 or a derogation under Article 49. Then data transfers to third countries that don't have an adequacy decision and also now to the US. Again, these are going to be restricted and an additional safeguard or a derogation will be required. And again, I've just put on the screen that the Privacy Shield is now invalid. I just wanted to touch on appointing an EU representative briefly as well. I mentioned this back at the beginning of the presentation, and this requirement is under Article 27 of the GDPR, and it will apply to UK-based controllers or processors that have no offices or branches within the EEA, but they are offering goods or services to or monitoring the behaviour of individuals located within the EEA. So if your organisation satisfies the three criteria I have just went through, then you may need to appoint a representative for after the end of the transition period. So what is a representative and what do they do? This is a commonly asked question. And again, it's understandable because organisations have so much to grapple with in terms of Brexit generally, never mind data protection and then this specific element of data protection compliance. So a representative may be a natural or a legal person established within the EU. This means that representatives can actually include law firms, consultancies, or other private companies. But the representative must be established in one of the member states where the data subjects whose personal data is being processed in relation to the offering of the goods or services to them, or whose behaviour is being monitored, are located. So for example, if you are offering services to individuals located in Germany, France and Spain, then you would need to appoint a representative in one of those three member states. You can't then just randomly appoint a representative, for example, in Italy. Organisations should also check local implementing laws and regulatory guidance for any specific requirements and provisions on enforcement and liability in relation to the representative in that jurisdiction. So what actually is the role of a representative then? Well, primarily the representative is responsible for liaising with the company, its EU-based data subjects, and also regulatory or supervisory authorities. So the representative would be responsible for responding to queries raised by supervisory authorities and data subjects located within the EEA. The representative can be subject to enforcement proceedings in the event of non-compliance, but this is really only in relation to non-compliance with its duties. So for example, its obligation to liaise with authorities or to maintain data processing records. It's also important to note that there are exceptions to the requirement to appoint a representative. So these exceptions are where you are a public authority or a public body, or where your data processing is only occasional, presents a low risk to data protection rights of individuals located within the EEA and does not involve any special category, i.e. sensitive personal data or criminal offence data on a large scale. Unfortunately, the data protection legislation does not arbitrarily define what is meant by large scale or low risk, so organisations really have to assess this, taking into account, number one, the nature of the data, two, the locations that the data is being sent to, and three, the amount of personal information contained within the data. And my advice would be, if your organisation is unsure if the processing is on a large scale, that you should err on the side of caution. And again, in terms of the appointment of a representative, we are hopeful that more specific guidance is going to be produced by the ICO.